All right, good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement and Variance Special Magistrate hearing. If you're here for the variance, you're in the right spot. We're going to do a code enforcement case first. So again, if you're here for a variance, you're in the right spot, but those matters will be taken up by the agenda after we do the code enforcement. However, if you want to talk to me for the variance, you'll need to stand and be sworn in just a couple moments. So, welcome to the City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez, and I'm a practicing appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, in regard to the code enforcement matters, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this point in time, the city attorney will swear in all witnesses, and this includes any members of the public that are affected by any of the code enforcement matters and want to speak with me today.
So anyone that's going to speak, if you could stand up, raise your right hand, I'm going to swear you under oath. Everyone that's going to speak, if there's any chance that you're going to speak, let's all swear you in right now. You swear that the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth. Thank you.
All right, and if you're a little nervous that first time, you're going to get one more chance in a few minutes, but please remember, if you weren't sworn, you will not be able to speak to me. All right, first matter on the agenda is CE-24-0021 for the property located at 113 145th Avenue East. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
We would call our witness Deputy Corey Snyder. Deputy, if you could tell us what your occupation is and your job responsibilities.
My name is Corey Snyder, Deputy Sheriff, Pinellas County. I am currently assigned to the City of Madeira Beach in both a law enforcement and code enforcement capacity.
All right. Are you familiar with this property located at 113 145th Avenue East?
Yes, I am.
Who owns this property?
Per the Pinellas County property appraisers, the owner name is an LLC, SNJ Management LLC, out of 195, 197 Governor Street, Patterson, New Jersey.
All right. And this case, is this a proactive case, or was it as a result of a complaint?
I received information from the City Business Tax Department about a possible apartment renting, and they did not have record of a business tax for this location, which led me to the location to do an inspection, at which time I determined that short-term rental activity was occurring.
Okay. So let's start going through the packet that we have here that will eventually tender into evidence so that we can do it chronologically. So pages 3 through 10 looks like it's a printout from Mike Twitty as the Pinellas County property appraiser. Is that the printout for this particular property?
That is correct.
All right. And it does reflect that the property owner is SNJ Management LLC?
That is correct.
Okay. And did you also print out the website for the tax collector's office for Pinellas County?
Yes, I did.
And what pages is that reflected in?
Page number 11.
Okay. And what does that reflect as the property owner?
It would be the same, SNJ Management LLC, 195, 197 Governor Street, Patterson, New Jersey, 07501.
Okay. So what was the first date that you went to the property to determine whether there was a violation at the property?
At February 3rd, 2024 at 8:50 a.m.
And when you got to the property, what did you determine?
I spoke to tenants Amy and Roger O'Neill, who told me that they rented the unit for the month of February through the 10th for approximately $2,000. It was captured on body camera.
Okay, and is that a violation of any particular city code?
Yes, it is.
Okay, and what is the code section that's being violated as a result of that interaction?
The code for this section is 110-201, which is an R2. This property is within the R2 zone of the city, and this zone has for a minimum of a 3-month rental period.
Okay, and so this interaction reflected a rental period for a shorter period of time than 3 months, correct?
That is correct.
All right. And did you, following that inspection of that property and talking to those people at the property, did you issue a courtesy letter to the property owner to advise the property owner of the code violations that were existing on the property?
Yes, I sent a courtesy letter to the owner on record from the Pinellas County Property Appraisers and the tax roll that advised them of the R2 rental rules within the city and the requirement for a city business tax.
All right. Did you also issue in that courtesy letter the registration information for short-term rentals as well?
That's correct also, 34-503.
Okay. So the courtesy letter that you're speaking of, is that in the packet at pages 14 and 15?
Yes, it is.
Okay. Did you get a response? Well, first of all, what were you asking the property owner to do when that courtesy letter was sent?
To cease, to obtain a business tax and cease short-term rental activity.
Okay. And did that occur?
No, it did not.
All right. Did you do a second inspection on the property subsequent to the first one on February 3rd?
Yes, I did.
And what date was that?
On February 24th at 9:15 a.m., I spoke to a Rita Miller who advised she rented the property, or one of the units at the property through Airbnb for the 222, 223, 224 for 3 nights for the total of $850.
Okay. As a direct result of that, did you issue a notice of violation?
Yes, I did.
Okay. And what date did you issue that notice of violation?
The same day,
All right.
2/24/2024.
And is that reflected on page 16 and 17 of the packet?
Yes, it is.
Did you send that by regular mail and certified mail?
Yes, I did.
Okay. And is that certified mail reflected on page 18?
Yes, it is.
Did you get compliance with regard to the violations at this property as a result of the notice of violation that was sent?
No, I did not.
Did you do a subsequent inspection then?
Yes, I did.
And what date was that?
On 3/21/2024 at approximately 10 a.m., I made contact with the property and spoke to multiple people at the properties, and 3 different renters provided me with statements as to the length of time they were staying, the amount that they paid, and the website that they used to obtain the rental units.
And did you have that reflected on body camera?
Yes, I
And
did.
can you play that for the special magistrate today?
Yes.
Okay. And approximately how long is this video?
4 minutes and 18 seconds.
Okay.
Hello. How you doing? I'm Deputy Snyder. Just compliance check, just 1 minute, your time there. Are you guys the owners?
No.
Renters.
Yeah,
Deputy Snyder. How long are you staying for?
I'm out.
You're out.
Tomorrow. No, not tomorrow, Saturday.
Saturday? Okay. Different, you guys are together?
I'm in the back. Why, you gotta
Okay.
look at our rooms?
Oh, there's 3. Oh, I thought there
No,
were just
there's
2.
there's 4 in the back
Oh.
and 2 up front. Yeah.
Holy cow, I thought there was just a duplex. Okay. You're leaving?
Yeah.
Get your name?
Matt Fleming.
Matt Fleming. And then how long did you stay?
A week ago, so we checked in the 14th, I think it was.
14th through
21st.
through today,
Yeah.
the 21st.
Yeah.
Remember what you paid?
Yeah, $1,300.
And then the website,
Florida Rentals.
Florida Rentals. Okay.
Well, she said she got it off of Vivo.
See,
but
some
I
are
found it
Airbnb,
Florida
VRBO, Florida Rentals. Okay. And which unit were you in?
free.
3. Okay. Very good. Thank you. It's painless. And you're in a different unit. You're in 2.
Two.
Can I ask you the same questions?
Yeah, we arrived on, let me look, I can tell you for sure. 8,
The 8th through the
23rd.
23rd. Okay. And then almost 2 weeks?
Yeah, well, 15 nights.
15 nights. And then do you remember what you paid?
Oh, this ought to be good.
Yeah.
Got a
I
deal.
tell you,
I like the questions with,
I know.
now I get to see.
Yeah, yeah.
I overpaid.
Yeah, it's you're a block from the beach, so I mean,
Oh, I know, I
yeah.
figured.
16 and 16, 32.
3,200. Okay, and which website did you guys?
Airbnb.
Airbnb. And then tell me your first and last name again.
Kevin Pease.
Kevin Pease.
Yep.
Very good. You guys enjoy.
Remember all that?
Yeah, I'm not. No,
He's got the camera.
I got a camera going. That's why I'm turning it. You guys are going to be famous. You're not at all. Very good. I can't. I'm 53 years old. I can't remember anything.
I just retired last year.
Okay, that's it. You want a card? Are you good? Okay, gentlemen, give it to him. He's staying. Okay. All right, thank you, gentlemen. I appreciate it. So there's 6 units or 8 units? 6. Holy cow. Okay. I looked at the appraisers. So the different zones had different renting regulations, and then we have to do inspections on them to see how they're renting and all that stuff. So
I think these are different sizes.
Are they, yeah.
The back 2 connect, there's people back there now.
Oh wow. Okay. Full house. So.
Well, they just left like
They-
literally 10
Yeah,
minutes.
they've
Did they?
been, like,
Okay.
since we've been here, 3 or 4 different.
How about this young lady? Hello, how are you? Are you the property owner? No. Are you renting?
Yes.
Can I get 1 minute of your time? Okay, all right, here we go. This is just a thank you, sir. I appreciate it. Just a compliance inspection. That's all. Just what's your name?
Kim
Kim. What's your last name, Kim?
Bone.
Okay, and then you're not the property owner. You're just renting.
Right, we're here for Tuesday through, we leave Saturday morning.
Tuesday that just
Yeah.
passed. Tuesday through Saturday.
Yeah.
Do you remember what you paid?
I can tell you.
You can tell me? Okay. While you're looking at, do you remember which website it was that you booked?
Hopper?
Hopper. Okay.
Why?
No, just because everybody's different. I think Airbnb and then
Oh.
Florida rental, Hopper,
Yeah, Hopper, and we paid $7.95
$7.95. That was Tuesday through
Friday.
Friday.
Well, no,
Tomorrow's Friday.
3 nights. Check in Tuesday, March 19th through Friday, March 22nd.
Right. Okay.
Okay, yeah, we leave tomorrow.
You leave more.
Yeah.
Okay.
Oh,
Very good.
I thought we left Saturday.
And then tell me your name again.
Kim.
Kim. Okay. Got it. Thank you. That's it.
All right.
Appreciate it. Thank you.
Okay. After having this interaction with these 3 different people on that date, March 21st, did you issue a notice of hearing for today?
Yes,
Okay.
yes, I did.
And was that notice of hearing sent by regular and certified mail?
Yes, it was.
And it was sent to the address listed at tax collector and property appraiser's office?
That's correct.
Okay. I just want to go through the packet a little bit more. So the notice of hearing that you issued was on pages 19 and 20 of the packet?
19, 21 through 23.
Well, that's the notice of hearing
Okay, yes,
and the
notice of hearing
statement of
is-
violation, correct?
Yes, 19 and 20 is the notice of hearing.
And the statement of violation is 21 and 22?
That is correct.
Okay. Have you heard anything from the property owner since you've issued this notice of hearing, a statement of violation for today's hearing?
In addition to the mailing of both regular and certified mail, we did post the property. I did receive a phone call from someone that identified himself as working for the management for the units. He told me over the phone that he was not going to be at the special magistrate hearing, probably, nor was the property owner. I did provide my phone number to give to the property owner to call me, and to my best of my knowledge, I have not received any phone calls, either City Hall or on my personal phone, department share phone, from the property owner.
Okay. All right, so let's just follow up then with the affidavit of service. That was shown in the packet at page 23, correct?
That's correct.
And this affidavit of service reflects that you sent the notice of hearing by regular mail, certified mail, and posted the property as well as posted City Hall, correct?
That is correct.
All right. And there were also some additional photographs in the packet at the very end. Could you go through those photographs and explain to me what they are, starting at page 24?
24 would be a copy of the certified mailing.
Okay. And that's the certified mailing of the notice of hearing and statement of violation?
That's correct.
All right. The next photograph, page 25?
25 would be a copy of the packet placed on the front of the property located at 113 145th.
Okay. And the next photograph, page 26?
Would be just a zoom out of the same thing showing the 113 address.
All right. And the last photograph in the packet?
It was just some information that's on the, one of the doors of the units, just information for residents arriving.
Okay. So have you or anyone else in the sheriff's office been to this property today to determine whether the violation continues to exist?
Yes, Deputy Krager, about 45 minutes ago, went to the property, spoke to Ania from Georgia, who reported she rented the property from 4/20 to today, used Airbnb as the resource to rent the apartments, or rent the unit, and paid $500. He also did capture it on body camera, which is available if you would like to see it.
Okay. I don't think we need to do that. So with regard to the three violations, failure, well, first of all, operating a short-term rental at a R2 property. There was also a failure to obtain a business tax receipt or an occupational license for the property. Has that been accomplished?
No,
Okay. And has the short-term rental been registered through as set forth in section 34-503?
no, it has not.
Okay, so the property is still in violation as of today?
That is correct.
Okay. And with regard to gaining compliance of the property, if the special magistrate finds that there is a violation, how much time do you think it would be necessary to take the property to come into compliance?
I've been working on this since February, so I wouldn't give them any more than 2 weeks to 30 days,
Okay.
whatever the city's opinion is on it.
All right, and with regard to the dollar amount of the fine, are you seeking the $250 a day for the violations?
Yes, I am, per code, yes.
All right, thank you. I have no other questions of the deputy. I would tender into evidence the agenda packet starting at page 3 and running through page 27, and ask that it be received.
All right, Ms. Trask, I'll go ahead and accept into evidence as exhibit number 1, pages 3 through 27 of the agenda package, and I guess as exhibit 2, the
video.
that was shown here
Thank
of
you.
the 3 different renters who all had what appeared to be short-term rentals. All right, is there anyone here on behalf of the owner of the property, S&J Management LLC? Anyone here on behalf of the property? Okay, seeing none. Mr. Trask, are there any other witnesses that the city would like to call?
No, we have no other witnesses.
All right, last call. Anyone here on behalf of S&J Management LLC or the owner of the property at 113 145th Avenue East? All right, seeing no one coming forward, are there any members of the public that have knowledge as to this code enforcement violation that would want to provide testimony here today? Okay, seeing none. Ms. Trask, so the city's position is, I heard 14 to 30 days, but is it $250 per violation and there's 3 violations on the property? Is that what the city would like me to find in my order?
There are 3 violations on the property, 110-201, 62-33, and 34-503. We're asking a fine of $250 a day for all 3 as one combined.
Gotcha. Okay. All right, based upon the evidence and the record developed, I do find that there is a code violation of all 3 code provisions cited in the notice. Based upon the testimony of Deputy Snyder, we'll give the landowner 30 days to come into compliance thereafter. It'll be a $250 per day fine. All right, any other code enforcement matters that are before me today?
No, there are not.
Okay. In that case, welcome to the City of Madeira Beach Variance Special Exception Use Special Magistrate Hearing. Again, my name is Bart Valdez, and I'm the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these variance requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be presented in the following order. First, the city will present its case and staff report, and the applicant may ask questions of the city's representative. Next, the applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Next, public comment will be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person. Last, public participation will then be closed. I'll deliberate and then make a decision to grant or deny each variance requested in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and the applicant will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city will administer the oath to anyone else who's not already taken an oath. If you expect to talk to me today during the hearing on your variance, then you will need to rise and be sworn. This includes any members of the public who are directly affected by the variance and may wish to provide public comment. Is there anyone else in the audience who was not sworn in the first hearing that now needs to be sworn in? All right, in that case, Mr. Trask, is the city ready to proceed on VAR 2024-02 for the property located at 14062 West Parsley Drive?
We are.
Go ahead, Mr. Trask.
The city would call Joe Petraglia, who is going to present this particular case. Joe, if you could please state your name, your job, occupation, and your responsibilities here at the city.
Yep. So my name is Joe Petraglia. I'm a planner 1 with the City of Madeira Beach. I primarily review permit applications for planning and zoning and also review variance applications and alcohol applications.
Thank you. Are you familiar with this particular variance application today, 2024-02, Greg Gallagher?
Yes, I am.
Okay. If you could go ahead and present the staff report and recommendation and go through the packet when you're completed
Sure.
with that.
Okay. Staff report and recommendation, special magistrate meeting, April 22nd, 2024. Okay. Application is VAR 2024-02. Applicant is Greg Gallagher. Property owners Patrick and Denise Wynn. Property address 14062 West Parsley Drive, Madeira Beach, Florida 33708. Parcel ID 10-31-15-34398-018-018. Legal description, Gulf Shores, 5th Ad Block R, Lot 18. Zoning and future land use is R1, single family residential, residential urban. The request is a 23-foot rear setback, a 6-foot 8-inch west side setback, and a 5-foot 8-inch east side setback. Specific code provisions are section 110-181, 2 rear yard, waterfront lots 30 feet, and 3 side yard, total side setback of 15 feet with a minimum of 7 feet on each side. 1, background. The current building was built in 1951 before the R1 single-family residential zoning district land development regulations were adopted and does not meet the current side yard or rear yard setback requirements. The existing structure is a slab-on-grade pre-firm structure. The applicant submitted a new construction permit application 2023-2208-BGDR to tear down the current building and build a FEMA-compliant home. The building department has reviewed and approved the permit, but is still pending planning and zoning review. The planning and zoning review has not yet been completed, yet partially due to the setback requirements being addressed by this variance request. The applicant is requesting to reduce the rear setback by 7 feet and the side setbacks by a total of 2.4 feet to match that of the current structure. As stated in section 82-2, the setback line for the rear yard was and will be measured from the outer edge of the seawall, as the property line is 10.3 feet landward. In the applicant's letter attached to the application, the applicant states city staff provided incorrect setback information. However, there are no records of any city staff providing any such misinformation. Additionally, the applicant's letter reports receiving an approval letter from Frank DeSantis before receiving Mr. Carrier's contradicting letter. It is worth noting that Mr. DeSantis's review letter was done on behalf of the building department, while Mr. Carrier's review letter was done on behalf of planning and zoning department, and all new single-family homes in Madeira Beach are required to be approved by both of these departments, which is what caused the applicant confusion. City staff are exploring rewording such letters to make sure future permit applicants understand the process for a permit review and avoid this confusion. 2, variance criteria, section 2-507B and analysis. Special conditions and circumstances exist which are particular to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, building, or other structures in the same district. Special conditions to be considered shall include but are not limited to the following circumstances. Findings: A, substantial or irregular shaped lot. This lot is an irregular triangle shape due to its location at the end of a cul-de-sac. As a result, the front property line is only 24 feet wide, rounding around the cul-de-sac. C, residential neighborhood character. Google Earth images show most of the other houses in this cul-de-sac encroach into the required side and rear setbacks. E, architectural and/or engineering considerations. The new home would be elevated and all construction features would be more resistant from floodwaters. 2, the special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify a variance. Findings: the need for this variance results primarily from the irregularly shaped lot, which is not a result of any actions from the applicant or the homeowner. This plot for the property and the existing home were approved before the current R1 single-family residential zoning district land development regulations were adopted. 3, granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. Findings: approval of the variance will not grant any special privilege to the property. Most properties in the zoning district do not have the irregular shaped lot that 14062 West Parsley does, which significantly limits the buildable footprint. Similarly, 14060 West Parsley Drive, directly next door on the same cul-de-sac, was granted SMVAR 2015-02 on April 14th, 2015. That approved variance reduced their rear yard setback to 16.42 feet, which is a further rear setback encroachment compared to what is being requested in this variance. 4, literal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the land development regulations, subpart B of this code, and would work unnecessary and undue hardship on the applicant. Findings: due to the irregular lot shape, literal interpretation of the setbacks would deny the homeowner a new single-family home of similar size to many others in the zoning district. 5, the variance granted is the minimum variance that will make possible the reasonable use of the land. Findings: the setbacks being proposed by the applicant in this variance are the minimum amount of variance required that will make possible the reasonable use of this land. The current structure already encroaches into the required rear and side setbacks. The setbacks being proposed by this variance match the setbacks of the existing structure. The proposed variance would not lead to an increase in the nonconformity. Additionally, it is worth noting that the applicant has revised their application and site plan on 2 separate occasions at the request of city staff to get to the currently proposed setback requests, as staff did not find the previous 2 requests to meet this criteria. 6, the granting of the variance will be in harmony with the general intent and purpose of the city land development regulations, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Findings: the proposed variance is in harmony with the general intent and purpose of the city land development regulations and will not negatively affect the character of the neighborhood. The harmony of the neighborhood and general scheme of the development of the neighborhood will be unchanged. Additionally, the new home proposed would be FEMA compliant, replacing the existing flood-prone and non-conforming structure, which would improve the area and public welfare. 3, staff recommendation. Staff recommends the approval of VAR 2024-02. Submitted by me, Joseph Petraglia. The attachments, we have the application with a survey of the existing structure and site plan with the proposed structure location, and public notice and mailing and postings. Pages 28 through 31 of the staff report, or the staff report, which I just read. Pages 32 through 34 is a letter from the applicant with the letters they received from the city on the permitting process. Pages 35 through 36 is their existing survey. Pages 37 and 38 is the applicant submitted pictures of the property location. Pages 39 through 47 is their application. Page 48 is the survey of the proposed structure. Page 49 is the mailing affidavit. Page 50 is the posting affidavit. 51 is the public notice. 52 is the affidavit, which were both sent in the mailings. Pages 53 to 54 are the mailing labels. And then pages 55 through 58 are the posting pictures.
Thank you. Just a few more questions. Have you received any written correspondence with either for or against this proposed variance?
Yes.
Okay, and could you go through those, please?
Yes, so I had a phone call from a neighbor that wanted to discuss it, and then I also was forwarded an email from another neighbor for disapproval of the variance.
And do you have copies of those with you today? I'm familiar with, and I provided a special magistrate with the one that is from Daniel and Andrea Wallaker.
Yes, that's what I have.
Okay. And it looks like just a few minutes before the meeting, there was another objection that was posted. Do you have a copy of that?
No, I did not receive, I didn't look at that email yet. I believe it just came in. The one that I have is from Friday, and it was forwarded this morning.
Okay.
And then I saw on my phone that they emailed at 2 o'clock.
All right, I'll read that one into the record. I do have it by email after the testimony has been completed.
Okay.
So you asking for your staff report to be placed into evidence?
Yes.
Okay, thank you. I don't have any other questions for you.
All right, go ahead and accept into evidence pages number 28 through 49 of the agenda package as exhibit number 1. All right, anything else from this witness before I call up the applicant or property owner for cross-examination?
No.
All
Thank
right.
you.
Is either the applicant or the property owner here in regard to this variance? All right, sir. Come on up real quick. In just a moment, I'm going to give you an opportunity to provide whatever information you want. However, this is your opportunity to ask any questions of the witness who just provided testimony today. Again, this is only an opportunity to ask questions and cross-examine. Do you have any questions for Mr. Petraglia? I do not. All right. Have a seat. You may be coming back up real soon. I don't know if Mr. Trask has any other witnesses.
I do not have any other witnesses, but once the public testimony is done, I'd like to read that other email into the record.
All right, sounds good. Okay, sir, come on back up, and first give me your full name and relationship to either the property owner or applicant.
Greg Gallagher, builder for the homeowners.
All right, Mr. Gallagher, what would you like to tell me about this variance request?
I think Mr. Petraglia did an excellent job in conveying everything that's on our mind and the homeowner's mind. Clearly, the homeowners are dealing with a very irregular lot. The newly proposed home that Mr. Petraglia and his team are recommending approval of this variance is still a very modest 2,000, 2,100, 2,200 square foot home. It does not go outside the boundaries of their existing non-compliant home. And the city would end up with a FEMA compliant home. And that's about it. I mean, it's pretty straightforward.
All right, thank you, sir. Mr. Trask, any cross-examination?
No, thank you.
All right. Mr. Gallagher, are there any other witnesses you'd like to call or any other evidence you'd like to provide to me at this time?
I do not.
All right. Thank you, sir. Have a seat. If I need anything else, I will call you back up, but have a seat for now. All right. At this point in the proceeding, we'll go ahead and accept public comment from anyone who is directly affected by this variance. So any members of the public that would like to come up and provide any information to me in regard to application VAR 2024-02 for the property located at 14062 West Parsley Drive, please come forward now. Okay, going once, going twice. No takers. Okay, Mr. Trask, would you like to read in whatever you believe was a timely filed objection to this variance?
Yes, I'd like to read an email that came from Tina Morrison from an email address of tina@conceptsonline.com. It was emailed on Monday, April 22nd, 12:41 p.m. to the Planning Department. The subject line is disapproval of VAR 2024-022. And then it reads, Dear Madeira Beach Planning Board, I am writing to express my disapproval of the proposed zoning variance. I feel that this is a new build and all should be built to all standard setbacks. There are no hardships that deem the excessive setbacks, it's misspelled, that this build is asking for. I am also very concerned with the fact of building so close to the seawall that it will impact all of the surrounding neighbors' seawalls. Thank you for your attention to this matter. Sincerely, Tina Morrison, 14048 West Parsley Drive. In addition to that, the other email was from Daniel and Andrea Wallaker. That was the one that I provided to you in paper format before the meeting. That one was sent to the city Friday, April 19th at 4:09 p.m.
All right, thank you, Mr. Trask. All right, Mr. Trask, anything else based upon those objections, public comment, or anything that the applicant has said that you'd like to bring to my attention?
No, staff recommends approval of the variance, though.
All right. Based upon the report of staff, the testimony of Mr. Gallagher, and the fact that the objections do not appear to be directed to any of the factors which I'm permitted to consider, I'm going to go ahead and grant the variance as recommended by the staff. Okay, let's move on to the next one, which is VAR 2024-03 for the property located at 13495 Gulf Boulevard. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
Going to call Mr. Jay Sturman. Jay, if you could state your name, your occupation, your responsibilities here at the city.
My name is Jay Stearman. I am a planner 2 here at the City of Madeira Beach, and my responsibilities are primarily permitting, and I also assist with long-range planning.
Are you familiar with this application, VAR 2024-03?
Yes, I am.
And did you prepare this staff report and recommendation?
Yes, I did.
Okay, if you would go ahead and present that staff report, please.
This application is for VAR 2024-03. The applicant is Boziak Hayes Architects, and the property owner is Tampa Home Pro Incorporated. The property address is 13495 Gulf Boulevard, Madeira Beach, Florida 33708. The parcel ID is 15-31-15-583-20-010-0080. Legal description, Mitchell's Beach, revised Block 10, lots 8 through 10, less road right-of-way per official records, books 4355, page 231, and book 4426, page 1135. The zoning for this property is C3, Retail Commercial Zoning District, and the future land use is Residential Office Retail. The request for this application is to allow 6 feet side yard setback along 135th Way, allow 6.5 feet rear setback at the northern half of the rear property line, and allow the elimination of the 5-foot perimeter landscape buffering requirement along 2 sections of the rear property line, one starting from 44.5 feet south of the northern corner of the parcel, spanning 33 feet, and the other starting from the eastern corner of the parcel, spanning 23 feet. The specific code section is 110-321, 2 and 3B, that the minimum rear setback of 10 feet shall apply in the C3 Retail Commercial District, and that the minimum side yard setback for lots less than 120 feet in width within the C3 Retail Commercial District be no less than 10 feet on one side. The other section is 106-35, 1 and 2, that the exterior of all vehicular use areas shall be landscaped with a buffer strip which is at least 5 feet in width, that when paved ground surfaces are adjacent to properties zoned exclusively for residential use, all land between the paved surface and the property line shall be landscaped, and that the landscaping shall include a buffer strip of at least 5 feet in width adjacent to the abutting property, containing a hedge or other durable screen of landscaping at least 5 feet in height. For background, the property is in the C3 Retail Commercial Zoning District and Residential Office Retail Future Land Use category. The lot comprises of contiguous lots 8, 9, and 10 from the Mitchell's Beach plat. 13495 Gulf Boulevard is on the southeastern corner of 135th Ave and Gulf Boulevard. The rear of the property abuts a one-way alley that separates the C3 Retail Commercial Zoning District from the R2 Low-Density Multifamily Residential Medium Zoning District. The widening and realignment of Gulf Boulevard in the early 1970s reduced the dimensions of the lot and further altered the shape to become a clipped parallelogram configuration. Many of the C3 commercial buildings in this area on Gulf Boulevard were built before current zoning code and do not meet the minimum setbacks, therefore are considered legally nonconforming. The widening of Gulf Boulevard exacerbated, or in some cases, could have created these nonconformities. The setbacks for the existing building at 13495 Gulf Boulevard do not conform to the C3 zoning district setbacks, with a side yard setback of 4.8 feet and a rear setback of 6.3 feet. Both the minimum rear and side yard setback in the C3 zoning district for this lot size is 10 feet. Therefore, the building is considered legally nonconforming. The 2-story building on the property was constructed in 1947 and was most recently used as a veterinary hospital. Tampa Home Pro Incorporated purchased the property in October of 2023 and intends to demolish the current building and construct a 4-story mixed-use building with 8 temporary lodging units, ground floor parking, ancillary rooftop amenities, and an ancillary ground floor restaurant. The proposed structure increases the current side setback from 4.8 feet to 6 feet, a reduction in the non-conforming setback. The reduction in the rear setback is due to the screening wall around the dumpster, which at its nearest point to the rear property line measures 6.5 feet. The current building has a rear setback of 6.3 feet exclusive of the rear wooden staircase, and therefore this request reduces the current non-conforming setbacks. The applicant also seeks an exception from the minimum 5-foot perimeter buffering landscaping along 2 sections of the rear property line, one starting from 45.5 feet south of the northern corner of the parcel spanning 33 feet, and the other starting from the eastern corner of the parcel spanning 23 feet in order to accommodate 4 of the 14 required parking spaces which protrude into this 5-foot perimeter zone. The total proposed landscape area, 2,021 square feet, is nearly double the minimum required, 1,011 square feet for the development. As for the variance criteria and analysis, special conditions and circumstances exist which are peculiar to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, building, or other structures in the same district. Special conditions to be considered shall include but are not limited to the following circumstances. We have findings for item A and item E. Item A, substandard or irregularly shaped lot. If the site involves the utilization of an existing lot that has unique physical circumstances or conditions, including irregularity of shape, narrowness, shallowness, or the size of the lot is less than the minimum required in the district regulations. We found the lot is irregularly shaped, which adds difficulty to the creation of a developable site compliant to setback, screening, and parking standards. The widening of Gulf Boulevard in the 1970s and subsequent roadway improvements also shortened lots fronting Gulf Boulevard, including the Mitchell's Beach plat block on which the subject site is located, as described in the background section of this report. Item C was also responded to, which is residential neighborhood character. If the proposed project promotes the established historic or traditional development pattern of a block face, including setbacks, building height, and other dimensional requirements. We found the project, if approved, would provide a greener, better screened, mixed-use layout, which more closely matches the surrounding character and seeks to accommodate the irregular angles of the property line and adjacent right-of-ways. Item E, architectural and/or engineering considerations. If the proposed project utilizes architectural and/or engineering features that would render the project more disaster-resistant. The new structure must be compliant with all current floodplain, fire protection, and Florida building code requirements. The special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify a variance. The hardships encountered are not self-created by the applicant. The lot was originally larger when the plat was first approved. The widening of Gulf Boulevard reduced the length of the lot. Number 3, granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. The variance requested is contextual to the site and narrow in scope. The proposed side and rear setback requests in the variance are less nonconforming than the existing structure's setbacks. Number 4, literal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the Land Development Regulations, Subpart B of this code, or Section 14-205 of the Code of Ordinances, and would work unnecessarily and undue hardship on the applicant. Found that landscape requirement and best practices for safe driveway and access design are at times incompatible with the irregular lot shape. The requested setback reductions from 10 feet to 6 feet at the side along 135th Ave and from 10 feet to 6.5 feet at the northern half of the property line appear to be the minimum required in order to satisfy other applicable requirements for the site's development program. Adjacent structures within the same platted block as the subject property, such as Tied the Knot Beach Weddings and the West Events buildings, have had their lots impacted by right-of-way widening and have narrower setbacks than what is currently permitted, rendering these buildings legally non-conforming as well. Number 5, the variance granted is the minimum variance that will make possible the reasonable use of the land. Found the variance is narrow in scope and suited to the specific dimensions and circumstances of the proposed site plan, namely the irregular lot shape. The current building does not meet the current setbacks, and this request is a reduction of nonconformity. The reduction of the landscape buffer requirements is minimal, and due to the small area of the lot is difficult or impossible to achieve with new parking standards that were not in place at the time of the construction of the current building. The adjacent buildings within the same platted block mentioned above currently have little to no landscaped area around the parking area and have much narrower front, side, and rear setbacks than what is currently permitted. Number 6, the granting of the variance will be in harmony with the general intent and purpose of the City Land Development Regulations or the Code of Ordinances when it relates to Section 14-205, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. We found the granting of the variance is in harmony with the general intent and purpose of the Land Development Regulations and is not injurious to the area involved or otherwise detrimental to public welfare. The subject property will have a similar character to adjacent commercial structures regarding lot coverage, setbacks, and orientation. The development of the new building will also create more landscape buffer area between the commercial and residential areas than currently on the site. The side setback will also increase the amount of open space between pedestrians and the building side along 135th Avenue as compared to the existing structure. The rear setback for the principal exterior structure wall will be 10 feet, the minimum permitted in the C3 zoning district. Staff recommends approval of VAR 2024-03 to reduce the required side setback from 10 feet to 6 feet from the property line along 135th Avenue, to reduce the rear side setback, the required rear setback, from 10 feet to 6.5 feet at the northern half of the rear property line, and to eliminate the 5-foot perimeter landscape buffering requirement along 2 sections of the rear property line, one starting from 45.5 feet south of the northern corner of the parcel, spanning 33 feet, and the other starting from the eastern corner of the parcel, spanning 23 feet. Submitted Jay Stearman, Planner 2, City of Madeira Beach Community Development Department, and attached are the site plan, boundary survey, variance application, applicant justification letter, property deed, and public notice mailing packet.
Jay, could you go through the rest of the packet and explain, besides the staff report that you just reviewed, starting at page 65 through the end of the packet, and explain which each of these items are?
Page 65 through 72 is the application from the property owner and applicant. Pages 73 through 79 are the site plans with the conceptual renderings, floor plans that were submitted by the applicant. Pages 80 is the applicant justification letter. There was a small error in the next part, which is the property deed. Page 69 should be behind page 81. These are the property deed documents which were separated, and they should not be. But after that is the affidavits of mailing and posting, which starts on page 82. And then page 84 is the public notice. Page 85 is the notice of intent to be an affected party. Page 86 is the mailing labels derived from the county property appraisers. And then finally, on page 92, we have the photographs of the postings.
Thank you. Can you go to the exhibit that would reflect the side yard buffering or the landscape buffering that is being requested, and can you explain the start and finish points that you're recommending in your staff recommendation?
Yes, that is on should be on page 74. Yep. So the 5-foot perimeter landscape buffering requirement, so one starts from 45.5 feet south of the northern corner of the parcel.
All right, where's that starting point? If you could, do we have a arrow that you can jump onto that and show?
I can work with Joe to get there. It's, on this screen, it would be the top left corner of the parcel. That is all the way to the parcel boundary, that corner.
Okay.
All the way in the top left. That is the northern corner.
Okay.
And so starting from 45.5 feet south of that corner, and then spanning 33 feet along that property line.
All right, that's the yellow portion, the first yellow portion?
That is the larger yellow portion,
parallelogram?
yes, near the middle portion of that property line, which
And
is the rear
why
property line.
is it needed, why is the landscaping buffering need variance in that particular location?
This is because we have parking spaces which are directly abutting the rear property line, which would not be normally permitted. They would need to be screened by that 5-foot perimeter landscaping buffer. The applicant was not able to fit the required parking spaces adequately into the area. 14 is the minimum that's required, and the parking spaces would not be long enough, or they would not be accessible in any of the layouts that they could find. So this is their final option was to apply for this variance in order to accommodate those parking spaces.
All right, so before we finish up on that particular location, the 14, 13, and 12, those are reflecting numbered parking spaces on the diagram?
That's correct.
Okay. The triangle at the back of the property that is highlighted in yellow, is that the other portion that is, that you are recommending approval of a loss of the buffering landscape requirement?
Yes.
Okay. And again, can you tell us how that was measured then, starting at the back property line? Is that correct?
We're starting from the eastern corner, which
Okay.
is that corner in the top right of the screen.
Okay.
There. And it spans 23 feet from that corner.
Okay.
So the only part of the perimeter landscape buffering that would need to be removed would be on that rear property line, since it is compliant on the side. So that's why that triangle is only at the rear side of that 5-foot perimeter buffer.
Thank you. All right, those are all the questions that I have. Are you asking for the special magistrate to receive the packet into evidence?
Yes, I am.
Okay.
All right, go ahead and accept into evidence as exhibit number 1 to VAR 2024-03, pages 59 through 94 of the agenda packet. And Mr. Stearman, I'm going to call up, anything else for Mr. Stearman?
No, thank you.
All right, I'm going to call up the applicant or anyone on behalf of the property owners to come up now. Sir, I do have one question for Mr. Stearman. Is there any difference between the request that the applicant has made and your recommendation for approval?
No, there's no difference per se. I think I attempted to make the language more clear as it relates to the parcel itself rather than what is proposed on this site plan.
Okay, understood. But it's not you're not imposing a different condition on what the applicant applied for. You're recommending approval. You're just setting forth exactly what you'd like to see in my order as to what the variant should read.
Yes, that's correct.
Okay, thank you. All right, sir, what is your name and relationship to the applicant or property owner?
Yeah, I'm Jack Bodziak of Bodziak Hayes Architects. I'm the one of the architects involved in the project, and I'm here to kind of present, and actually most of it's been well presented by the city. The property, as you know, the main
Hold on,
problem-
Mr. Boziak, because I'm going to give you a chance to say everything you want. Do you want to ask
Okay.
any questions of
No,
Mr.?
I don't.
Okay, all right. Don't go anywhere, stay right there. Mr. Trask, does the city have anything else?
There's no other witnesses.
All right,
you.
Mr. Boziak, now go ahead and tell me whatever you want to
Okay.
tell me about the project.
This property, the biggest thing about this property is the adverse effect that, not only the adverse effect that the taking that happened originally on Gulf Boulevard, but also the fact that the property, as you can see on the diagram, really has kind of a strange angular twist to it. And it made putting a square building squarely parallel to either the rear or the side property line very difficult. The yellow areas that you see, I'll cover this. This is one of the later things, but you can see we maintain the landscaping on the corner, which is what the public sees for the most part on 135th, and traveling down the alley. We really had a lot of trouble getting the parking and the building to fit on the adverse size of the site. The yellow section is where the parking spaces do back out. On the far right corner, you can see the landscaping actually was maintained back up in the area between the alley and that yellow spot, but the yellow spot is where we had to eliminate the landscaping to fit one of the required parking spaces in. Basically, the site is approximately 10,000, a little over 10,100 square feet, and the adverse effect of the diagonal nature of the site, then shortened by a considerable amount by the taking on the road, created some unusual setbacks. The existing building is actually 7.7 feet off of Gulf Boulevard, we're going to increase it to the code required 25 feet. The 135th side of the street, the required is 10, and we're increasing it from the 4.8 to the 6 feet, which is still a deficit of about 4 feet, but it is an improvement. On the alley in the rear, the encroachment primarily in the rear, as you can see, is not the building itself, the main building, it's the dumpster. We had a hard time locating the dumpster, so we located it so that access to it for emptying the trash on pickup days is a lot easier. Once again, the encroachment of the dumpster into the site, as you can see, in itself was quite a undertaking. But it does, that is the encroachment in the back. It is not the main building. I just wanted to bring that out. The redevelopment code applies. We didn't want to go through the redevelopment code because we felt that we could handle everything within this with these three, what we consider to be reasonable variances. The functional obsolescence of the building that's there has been an issue. The site is almost entirely paved and covered by building from one end to the other in its present state, and naturally we greatly improve the pervious surface area on the site. We're requesting this modification to the setbacks and the elimination of the required landscaping on the alley. Aside from that, all other conditions meet the Florida Building Code, the zoning regulations, and FEMA regulations. We've designed everything within that spectrum. The space on the ground floor is a 1,400 square foot proposed ancillary space that is allowed within the regulation of the 8 units that we are proposing. Aside from that, I mean, it's been well presented by the city, and we think it's a reasonable request, and we would like to request that be approved.
Thank you, Mr. Boziak. Mr. Trask, any questions?
I have a few questions. Mr. Brodziak, have you had the opportunity to review the staff report and recommendation?
Yes.
Okay. And you have no objections to the staff recommendation as it's laid out in the staff report, correct?
None whatsoever.
Thank you.
Thank you.
Mr. Trask, you beat me to it, so same thing I'd have. Mr. Boziak, would you like to call any other witnesses or present any other information to me today?
No, I believe I've presented between the staff report, which we have met with the staff, fully concur with their determinations, and we would respectfully request that you consider approval of this request.
All right. Thank you, Mr. Boziak. If there are any members of the public that comment and you want another shot, tell me anything. I will give you that shot in just a few minutes. All right. Are there any members of the public that would like to talk about VAR 2024-03? That is the one we're talking about right here, this one up on the screen. All right, come on up, sir. And what I need you to do is give me your full name and address, or tell me how you're affected by this variance.
My name's Paul Byam, 13500 First Street East. We live in Eco Village, just adjacent to the property going in.
All right, hold on, sir. I got Paul as a first name. Spell your last name for me.
Byam, B-Y-A-M.
Okay, sir. All right, I understand your, go ahead, sir. I didn't mean to cut you off. Go ahead.
Nope. I'm a resident in the neighborhood, adjacent to the property. There's been a lot of activity going on there with the 6 West, with events going on, activities going on. Quite a popular place. It's bringing a lot of activity to our neighborhood, some good, some bad. Noise all night, not all night, till 10, 11 o'clock. I don't know if there's noise ordinance, but the parking has become available, or has become a problem. It's filling up our neighborhood streets. When there's emergency vehicles that need to come down into the Gulf Boulevard area and First Avenue, it's blocking up areas for vehicles to get through. They're talking about the alleyway. They're bringing in buses to drop people off for this entertainment venue. They're going through a one-way alley in our backyard the wrong way so they can get their bus through. I don't think this is real safe. I'm totally opposed of everything that you guys have talked about on this building. I guess I should have attended more meetings. And I will talk to our neighbors around the area. We sure do like the beach. We moved here from northern United States to get here, Minnesota, to enjoy the beach. Now we're here partying every weekend with the event center. Adding that property there is just going to create more and more excitement for everybody with all the VRBOs around us. It's just turned into nothing but a party. I understand we're in a vacation resort community, but let's have a little bit of civility and life around here. I'm opposed to everything that they've talked about.
All right, sir. Thank you for providing your comments today. Appreciate that. Are there any other members of the public that would like to comment in regard to VAR 2024-03? Okay, going once, going twice. All right, we'll close public comment. Mr. Bosiak, would you like to provide any additional information based upon the public comment?
No additional information, but I do think that I understand the gentleman's consideration about the venue event next door, which is a fairly substantial event holding place. I don't think that should be necessarily affecting our request, though. Thank you very much.
Mr. Trask, same question to you in that regard. You want to address public comment?
I have nothing, thank you.
All right. All right, based upon the staff report, the evidence provided today, I'm going to go ahead and grant VAR 2024-03, and I'm going to use the exact language that the staff recommends on page 64 of the packet. All right, let's move on to the last one, which is VAR 2024-04. This is for the property located at 13510 First Street East. Is the city ready to proceed?
We are.
All right, go ahead, Mr. Trask.
We were going to have Joe Petraglia present this particular case. Joe, you've already been sworn in. Are you familiar with this particular property and the variance request 2024-04?
Yes, sir.
Did you prepare the staff report and recommendation?
Yes.
Okay, if you want to go ahead and present that, please.
Sure. Okay, staff report and recommendation, special magistrate meeting April 22nd, 2024. Application is VAR 2024-04. The applicant is David Green and Cecilia Donovan, and that is also the property owner. Property address is 13510 First Street East, Madeira Beach, Florida 33708. Parcel ID 15-31-15-58320-009-0070. Legal description: Michelle's Beach, revised BLK 9, Lot 7, and NE apostrophe LY 1/2 of VAC alley on SW PER deed BK 1558 PG 368. Zoning and future land use is R2, low density multifamily residential medium. The request is to reduce the side yard setback by 1/2 foot to allow a 3-foot wide utility deck. The specific code provisions are section 110-206. 3, side yard A, single-family lots less than 50 feet wide may reduce the total side setback to 10 feet with a minimum of 5 feet on either side. And section 110-206, 4, for only those dwelling units with the lowest habitable space elevated at or above the elevation designed on the flood insurance rate map firm, exterior stairs, platforms for mechanical equipment, and chimneys shall be allowed to extend into the side yard setback, but only to a depth of no more than 1/2 of the required setback. Such equipment shall be located in the middle 1/3 of the structure. All mechanical equipment must be appropriately shielded from public view with materials including but not limited to louvers, lattice, and the like. 1, background. The structure was built in 2016 under another variance, VAR 2014-16, which granted 13510 First Street, amongst other addresses within Eco Village, a 5-foot setback on both sides of the house, which is now allowed by right, and the ability to add an additional 1 foot to the 50% encroachment permitted for platforms and mechanical equipment under section 110-93-3A. Any addition, altercation, or renovation to a non-conforming structure cannot increase the degree of nonconformity. Therefore, the applicant cannot extend the existing platform by right. The city clerk was not able to locate the order granting the variance to verify if the expiration date if an expiration date was given. And Section 2-503F states that all variances granted by the special magistrate and not acted upon within 1 year of being granted shall automatically expire. City staff recommended to the applicant that they should apply for this additional variance. In this variance, the applicant is only requesting an additional 0.5-foot encroachment into the side setback to extend the existing utility deck and allow for access to accompanying electrical components to 2 Tesla power walls, which is half the 1-foot additional encroachment approved from the previous variance. Duke requires such platforms to be 3 feet wide. However, city land development regulations only allow for a 2.5-foot encroachment into the setback for mechanical equipment and platforms, which is 50% of the allowable 5-foot setback. 2 variance criteria and analysis. Special conditions and circumstances exist which are particular to the land, building, or other structures for which the variance is sought and which do not apply generally to the lands, buildings, or other structures in the same district. Special conditions to be considered shall include but are not limited to the following circumstances. And city staff found C, residential and neighborhood character. Many houses in Eco Village, including 13510 First Street, already have utility decks that encroach into the side yard setback by more than 50%. And also findings of E were found. Architectural and/or engineering considerations. The purpose of the proposed utility deck is to install a modern energy storage units and replace equipment elevated above the base flood elevation to support additional solar panels to power the home without a generator during a power outage. 2. The special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify variance. Findings. This is not a self-created hardship because the applicant does not have enough existing side yard space to add a compliant platform without encroaching more than 50%. The applicant has not yet begun work and has been researching how to complete this project while complying with all applicable codes. 3. Granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. Findings. Other properties located in the Eco Village were granted the same variance in 2016 and would also be able to install the same power walls being proposed by this applicant. 4. Literal interpretation would deprive the applicant of rights commonly enjoyed by the other properties in the same zoning district under the terms of the land development regulations, so Part B of this code, and would work unnecessary and undue hardship on the applicant. Findings. Literal interpretation of the setbacks would deny the homeowner the ability to extend their utility deck, while other property owners located in the R2 zoning district would be able to build one by right. 5. The variance granted is the minimum variance that would make possible the reasonable use of the land. Findings. Literal 3 feet is the minimum width of such utility decks allowed by Duke on other codes. Therefore, the additional 0.5 foot being requested by the applicant is the minimum allowable to install such equipment, which is a reasonable use of the land. Additionally, it is worth noting that the applicant has reviewed other options as to locations for such equipment before settling on the side yard. 6. The granting of the variance will be in harmony with the general intent and purpose of the city land development regulations, and that such variance will not be injurious to the area involved or otherwise detrimental to public welfare. Findings. The proposed variance is in harmony with the general intent and purpose of the city land development regulations and will not negatively affect the character of the neighborhood. As previously stated, many other homes located in the Eco Village, including 13510 First Street, already have utility decks that encroach into the required side yard setback. The harmony of the neighborhood and the general scheme of the development of the neighborhood will be unchanged. 3. Staff recommendations. Staff recommends approval, submitted by Joe Petraglia, which is myself. The attachments include an application with the existing survey, images of the utility deck, markup of the proposed utility deck extension and equipment, a public notice of mailing and posting. That can be found on pages 99 through 107 are the application that was submitted to the city. Pages 108 to 121 of the agenda packet are the images and the existing survey provided by the applicant. Page 122 is the posting affidavit, and page 123 is the mailing affidavit. The following two pages, 124 and 125, are the public notice that was sent out, followed by 126, the notice to be affected party that was sent out. 127 through 131 are the mailing labels, and 132 through 134 are the posting pictures.
Have you received any correspondence or phone calls from any person that would deem themselves to be an affected party?
No.
Okay. Are you asking for the special magistrate to receive into evidence the staff report and recommendation that you prepared, and it's in the packet?
Yes, I am.
Okay. All right, I have no other questions. Thank you.
All right, we'll go ahead and accept in as exhibit number 1 to VAR 2024-04, the pages of the agenda package, which are pages 95 through
34,
134?
Yeah.
Gotcha, 134. Mr. Traglia, I just want to make sure, at page 115 appears to be some kind of sealed document. Is that part of the elevation certificate for the property? It's right after that page.
Yeah, that was
It's
part of-
illegible to me, and if that's something critical that's in the record, I would just ask that the city supplement the record with a legible copy after the hearing, if that's critical.
I don't find it to be critical. That's part of the elevation certificate that the applicant provided.
Okay, no problem. All right, is anyone here on behalf of the applicant or the property owner? All right, sir, come on forward. And what is your name and relationship to either the applicant or the property owner?
My name's Joe Lyons. I work for Lunex Power. I'm a solar contractor that Mr. Green is contracted with to try to build this stuff.
All right, Joe, you said Lyons is your last name?
Lyons, yes, sir.
Excellent. All right, sir, in a minute, I'm going to give you an opportunity to tell me anything you want about this. You have the right to ask any questions of Mr. Petraglia. As you probably heard, he's recommending approval with no conditions. Do you want to ask him any questions at this time?
No, sir.
All right. Does the city have anyone else?
No other witnesses?
All right. Mr. Lyons, what would you like to tell me about this or show me about this application that you have or has been submitted on behalf of the property owner and applicant?
I have nothing for you guys. I think that they've presented everything clearly and accurately.
All right. Mr. Trask, any questions of Mr. Lyons?
No, I don't. Thank you.
All right. Mr. Lyons, anything else you'd like to show me, any other witnesses you'd like to call or anything like that?
Thank you, sir.
All right. Have a seat, sir. Are there any members of the public that would like to provide comment in regard to application VAR 2024-04? Any members of the public? All right. Come on forward, sir. And I know your name already, but go ahead and, for the record for this hearing, go ahead and give us your name again, sir.
My name's Paul Byam. I'm a resident of Madeira next to Mr. Green, and I think it's okay that he could put the wall up.
All right, so we'll note that as no objection and a
No
support.
objection from the neighbor.
Okay,
All
great.
right,
Thank you, sir. All right, Mr. Trask, anything else?
No, staff recommends approval.
Okay. Mr. Lyons, do you want to say anything else? Okay, I'm going to go ahead and grant variance number 2024-04. All right, is there anything else before me today, Mr. Trask?
No, sir.
That will conclude today's hearing. Thank you, everyone, for coming.